Hi, my name is Samantha and I'll now be going through the question. So, for an introduction, the dynamics of legal compliance with multilateral environmental agreements (MEA), which addresses climate change, are inextricably linked to the legal systems of the countries involved. These systems, which can be broadly classified as monist or dualist, influence how international treaties are integrated into and implemented under national law. Despite universal adoption of climate-related MEAs, differences in compliance with emission reduction objectives highlight substantial issues stemming from these fundamental legal divisions. This video investigates the impact of monist and dualist legal systems on treaty compliances and examines the legal and practical issues each system has when aligning domestic and international duties and suggests solutions for improving adherence. So, for part 2, we will first look at the principles of the concepts involved. So, the relationship between international law and national law has been the subject of much doctrinal debate. At opposing extremes are the monist and dualist theories or systems. So, the monist standpoint regards international and national law as components of a single legal order. Monism holds that international law rules can be applied directly in a state's domestic realm, and international law is immediately incorporated into the national legal system without the need for any domestic implementing legislation. And if there is a contradiction between the two systems, international law takes precedence. And also, monists believe that international law is superior than national law. Moving on to the dualist approach, holds that international law and national law are distinct legal systems that exist independently of one another, and that international law governs the relationship between states, whereas national law governs the rights and obligations individuals have inside a state. For international law to be applicable in the national legal order, it must first be turned into national law through national legislation. Only after such a transition may individuals within the state benefit from or relying on international, now national law. When dealing with the same subject matter, these two systems may clash. In this instance, each system follows its own laws. International courts would apply international law, whereas national courts would apply national law. Moving on to part 3. For the legal challenges in compliance in a monist system, while monist systems provide a streamlined approach to integrating international law, several challenges can undermine compliance with MEA targets. Firstly, in monist systems, treaties often hold equal or superior status to domestic laws. However, conflicts arises when existing domestic law contradict treaty obligations, requiring courts to resolve inconsistencies. These conflicts may lead to legal uncertainty and hinder the implementation of environmental commitments. In Flaminio Costa against Enel, the European Court of Justice emphasized the supremacy of EU law in member states, demonstrating how monist systems prioritize international obligations. However, this primacy can clash with constitutional provisions, as seen in France, where the Constitutional Council has occasionally resisted international obligations that infringe upon national sovereignty, particularly in the context of trade agreements with environmental implications. Secondly, courts are often empowered to enforce international treaties directly. While this can ensure compliance, it may lead to perceptions of judicial overreach, particularly when courts make politically sensitive decisions. Such rulings may lack popular support, undermining the perceived legitimacy of international obligations. In Uganda Foundation against State of Netherlands, the Dutch courts mandated the government to increase its greenhouse gas reduction targets based on international climate commitments. While hailed as a victory for environmental activism, the case also highlighted tensions between judicial enforcement of international norms and domestic policy autonomy. Lastly, even when treaties are directly enforceable, monist states may lack the institutional frameworks necessary to implement them effectively. This includes insufficient regulatory bodies, weak enforcement mechanisms, and inadequate technical expertise. Developing countries like Paraguay, despite monist frameworks, struggle with institutional weakness that hinder the realization of international commitments. In cases like Sahoya, Maxia, indigenous community against Paraguay, enforcement failures underscore the limitations of judicial rulings in driving systematic change. In dualist systems, treaties require legislative translation into domestic laws to become enforceable. While this approach emphasizes national sovereignty, it also introduces unique legal hurdles. Firstly, legislative delays. Translating international treaties into domestic law often involves lengthy parliamentary processes. This delay can prevent timely compliance with environmental obligations, particularly when political dynamics impede consensus. The United Kingdom faced criticism for delays in implementing EU environmental directives, such as the Urban Wastewater Treatment Directive, and these delays were often attributed to the need for legislative approval and political disagreements over compliance costs. Secondly, dualist systems enable governments to selectively incorporate treaty provisions, leading to partial or inconsistent compliance. This practice undermines the comprehensive implementation of environmental green agreements and creates legal ambiguity. In the United States, the lack of a Senate ratification for the Kyoto Protocol reflected a broader trend of selective engagement with international environmental law. While some provisions were implemented domestically, the absence of binding commitments hindered global efforts to reduce emissions. Lastly, the fragmentation of federal systems. In federal dualist systems, subnational entities often retain significant autonomy over environmental regulations. This decentralization complicates the harmonization of domestic laws with international commitments, as local priorities may diverge from national obligations. In Australia, states and territories play a pivotal role in implementing environmental policies. The federal government's ratification of the Kyoto Protocol faced resistance from certain states, delaying comprehensive adoption of climate measures. Moving on to part 4. One of the first steps towards improving adherence is to design treaties that are clear, actionable, and adaptable to varying legal systems. Provisions must explicitly address the procedural difference between monist and dualist states to ensure compatibility. Treaties should include specific, measurable, and time-bound commitments. For instance, the Paris Agreement introduced nationally determined contribution (NDCs), allowing countries to set their own targets while adhering to a common global framework. This flexibility accommodates diverse domestic contexts while ensuring accountability. The GAP Sikoyo Nagi Maros project case, adjudicated by the International Court of Justice (ICJ), underscores the importance of clear treaty obligation. The lack of specificity in the original treaty led to disputes over compliance, demonstrating the need for well-defined provisions. Treaties should provide model legislative templates or guidelines for implementation, especially for dualist systems that require domestic translation. Many nations lack the institutional capacity to enforce international obligations effectively. Capacity building initiatives can address these gaps by strengthening legal, technical, and financial frameworks. Establishing specialized environmental courts or agencies can enhance enforcement. For an example, India's National Green Tribunal (NGT), established in 2010, has played a pivotal role in addressing environmental disputes and enforcing international norms domestically. legal professionals and policymakers must be trained in interpreting and applying international environmental law. Partnership with international organizations like the United Nations Environment Programme, UNEP, can facilitate such initiatives. The Green Climate Fund, established under the UN FCCC, is an example of a mechanism designed to support developing countries in meeting their climate commitments. Expanding such funds and ensuring timely disbursement can improve compliance. In pulp mills on the river Uruguay, the ICJ emphasized the importance of scientific and technical assessments in environmental governance. Capacity building programs could enable nations to fulfill such obligations effectively. In dualist systems, legislative delays are a significant barrier to compliance. Streamlining these processes can enhance the timely incorporation of treaty obligations into domestic law. Parliament should adopt fast-track procedures for treaty implementation, similar to those used for trade agreements. This approach could reduce delays caused by political debates. Governments could be granted limited authority to implement treaty provisions through executive orders or secondary legislation, subject to judicial review to ensure accountability. The delay in implementing the Kyoto Protocol in the United States highlights the consequence of legislative inefficiencies. Legislative reforms could have expedited the process, preventing years of non-compliance. Courts in both monist and dualist systems play a critical role in enforcing international obligations. Judicial capacity must be enhanced to ensure consistent and fair adjudication. Training judges in environmental law and international treaties can improve the quality and consistency of rulings. The Aarhus Convention, which promotes access to environmental justice, provides a framework for such capacity building. Establishing dedicated courts or tribunals can improve the adjudication of environmental disputes. For instance, Pakistan's Green Bench system has effectively addressed compliance issues under international environmental agreements. The Urgenda Foundation against the Netherlands also demonstrates the transformative role of courts in enforcing international climate commitments. By mandating the Dutch government to meet higher emission reduction targets, the judiciary bridged the gap between international obligations and domestic implementation. Effective monitoring and accountability systems are essential for ensuring adherence to MEAs. These mechanisms must be robust, transparent, and enforceable. Treaties should mandate periodic reporting of progress, coupled with independent verification. For example, the Paris Agreement's transparency framework requires countries to submit regular updates on their NDCs. Establishing peer review processes similar to those used by the World Trade Organization can foster mutual accountability among nations. Expanding the role of compliance bodies such as the Kyoto Protocol's Compliance Committee can enhance enforcement. However, these committees must be empowered with stronger enforcement tools such as sanctions for non-compliance. The ICJ's decision in Whaling in the Antarctic highlighted the importance of monitoring compliance with international obligations. The court found Japan's whaling program in breach of the International Convention for the Regulation of Whaling, emphasizing the need for stronger oversight mechanisms. So in conclusion, compliance with multilateral environmental agreements varies greatly due to structural variations between monist and dualist legal systems. While monist systems suffer constitutional problems and judicial activism, dualist systems deal with legislative delays and selective implementation. Addressing these difficulties necessitates a multidimensional approach that includes capacity training and improved accountability procedures. By encouraging greater congruence between international obligations and domestic legal frameworks, the global community could improve collective efforts to address climate change and achieve sustainable developing goals. That is all from me today. Thank you.